Part 5 Error and Unfairness. The greatest mistake is to imagine that we never err. Thomas Colella. Lay persons generally have two complaints against the law. The first is that law is too complicated and complex and cannot be understood. We have considered these matters in the preceding part. The second is that law is neither wrong or unfair. The two are often, but not always, related. The assertion that the law is wrong would suggest that neither the current law is wrong or the judge's perception of the law is wrong. Naturally, the above errors would lead to unfairness or injustice, but there are other contributors to unfairness or the perception of unfairness. They include the challenge of polarity, the ability to discern if the situation at hand is binary or ranged. Inclusiveness, the difficulty of precise circumferencing and avoiding and inclusion and over-inclusion. Perceptions, how the law sometimes uses perceptions in respect of the elements of the legal principle. The challenge of causality, the difficulty of determining an actual cause of a particular injury, and where there were several causes, the correct appointment of liability amongst the causes. Green area unfairness, simply because the situation is really borderline or gray, and the law or the judge is faced with two options, both of which are not entirely satisfactory. Justice or law that for a particular dispute before a court, there is a fundamental question of whether the judge's rule is to administer justice or to administer law. A judge who focuses on the former would be inclined to interpret, bound, or change the law, whereas a more conservative judge would apply the law, even if the outcome is not so just and. Hindsight reasoning. As with other disciplines and areas of life, the law sometimes falls prey to hindsight reasoning.